Okay, top of the morning, top of the evening, top of the night, whatever time zone you are on. We are live. I am back. I don't know what I hit on my other footage video that made them in the stream, but apologies, everyone. So, hello, Jen J, Mrs. Purpose 3000, to the people who were in the bushes. We are back. A moment of silence again because we need to finish up this conversation. All right. So, again, digital forensics is coming to everybody. Now, when I got to Donald Trump name, I noticed it cut off. Uh, I'm just going to let the record show. And when you're dealing in the realm of science and computer science, the records will show. You can think you're getting away. You can think you're deleting information. You can think you're hiding information on your electronic device. People in my field and people like myself, it is our responsibility to go in and to retrieve that information. And places that you may not even know are within your device and within your hardware. That's, you know, you have software, you have hardware. It's the software, the hardware, and the data. Software, hardware, and the data. It's the software, hardware, and the data. And the people who utilizes the data. So four things. Let's get it straight. Software, hardware, data, and the people who utilizes those devices, like us. Now, let's get to it. Okay, so I want to finish up, and I want to refer back to this case because this is important, and this will continue to come up in future cases. ESI, which stands for electronically stored information, is going to continue to come up in future cases as it was in previous cases. We saw it in the Kyle Rittenhouse case. We saw it in everybody's cases of late. Johnny Depp and Amber Heard, the Amber Geyer case when she murdered Botham Jean. We see it in the Breonna Taylor's case. We've seen it in case after case. Forensics, digital forensics is everything because evidence is now in an electronic form. Some evidences are maintained and obtained and collected in an electronic form. And so it is vital that steps are followed. Okay. So, like I said, electronically stored information is either going to work for or against people. And again, hello to the people in the bushes. Um, so I want to go right here to a case. All right. And it is vital that attorneys, and I'm happy to see in this Robert Sylvester Kelly trial with his two co-defendants that will take place in Chicago, Illinois, towards the end of this month. I am really glad to see a team of attorneys um, who seems to have a good understanding of electronically stored information and how it could be admissible or non-admissible, inadmissible in the court of law. So that's good to see them going down that path like they should in pre-trial motions prior to the trial taking place. Um, I concur with them. If you are working for your client, that's the way it should be done because you are either a attorney that's worth the salt your savor, or you are a deadbeat, ineffective attorney, and your client needs to turn around and see you for non-effective assistance and counsel. I've been good, Miss Purpose. How have you been? Hopefully, you've been doing good, Mrs. Purpose. So good to see you. Nice to know you're still in the land of the living. All right. So I'm going to refer back to this case, okay? So I want to give an example of, and I'm streaming directly from, oh, good, Mrs. Purpose. I'm streaming directly from YouTube. No third-party applications are connected to this. So you're just going to have to listen as I read. I can show you. You know, this is the case I'm reading. All right. So, evidentiary rules. All right. So, in my field and in any under the federal rules of evidence, we have what's called the best rules of evidence. Okay. Best evidence rule. And then, it's exceptions to the rule. All right. So, but when it comes to digital evidence, and I want to read from a case that happened in 2004. And it was United States versus Burnett, 363 F3D 947, Ninth Circuit Court, that is, 2004. Okay, so this is what happened. The Coast Guard boarded a boat along the coast shores of Southern California and found drugs. At the trial, the government had to prove that the boat came from Mexico in order to convict Burnett of drug importation. The government could not produce any witness who saw Burnett's boat cross the border. But Officer Chandler discovered a global positioning system, GSP, global positioning system. But I need you to pay attention and listen to this. While searching Burnett's boat, and testified that the GPS, and I think I said the GSP, so let me say it right. The GPS, the global positioning system, revealed that Burnett's boat had traveled from Mexico waters to San Diego Bay. The GPS came with a backtrack feature that graphed the boat's journey that day. Now, pay attention. This is a real case. And again, this is United States versus Burnett, 363 F3D 947, Ninth Circuit Court, 2004. Now, GPS was on the boat. Yes. So, officers saying, well, GPS is on the boat. Trackback feature was enabled. But continue to listen to this. All right. The feature that graphed the boat's journey that day. Chandler's testified. This is the officer testifying that he pressed the backtrack feature and saw the mapping of Burnett's journey from Mexico territorial waters to San Diego Bay. Chandler's acknowledged, however, and all of this matter when it comes to electronically stored evidence being admissible in the court of law, being admitted into the court of law. And if you got a good attorney, like I said, they will challenge everything on every wind and wave if they're worth the salt that they savor. They either are or they aren't. And if you have ineffective assistance of counsel at any point in time, you can always terminate your attorney and get another one. That he pressed the backtrack feature and saw the mapping of Burnett's journey from Mexico territorial waters to San Diego Bay. Chandler's acknowledged, however, that he had not taken possession of the GPS device itself, mistake number one, or obtained a record of the data contained in it, mistake number two. His testimony was only evidence of a trajectory the GPS recorded. Okay. He was only given a trajectory of what he thought was recorded from a GPS. He had no original documentation. He had no data. All he had was his testimony, word of mouth. Now, the Bennett court case found a violation of best evidence rule first. So his attorney said best rules of evidence. Now, this is where we flip it on you. First, GPS display of the trajectory observed by Chandler was a writing or recording because it was geographical representation of a positional data compiled by the GPS. Second, Chandler did not directly observe Bennett's boat travel the path depicted by GPS. Thus, Chandler's testimony concerned the content of the GPS, which in turn was evidence of Bennett's travel. The court concluded that proffering testimony about Bennett's bordering crossing instead of introducing the GPS data, therefore, was analogous to proffering testimony describing security camera footage of an event to prove facts of that event instead of introducing the footage itself. He just came with his word of mouth. I observed this, and it said this, and it said that. Best rules evidence. When you have self-authenticating documents, which electronics are supposed to be, why would you not bring the electronic in? Let me say it again. When you have self-authenticating devices, like laptops, like cell phones, like desktops, like printers, any type of peripheral device, why would you not bring the device in itself? Like surveillance units. Now, to satisfy, continuing on, the best evidence rule, the government was required to produce the GPS itself. Or a printout or other representation of the GPS data. They didn't do that. That's why they lost that case in 2004. When it comes to digital evidence, the judge is not supposed to care about what you're saying. They're supposed to care about the evidence that can be produced. In cases where people go wrong is they want to follow the emotions. This is not about following your emotions when we're dealing with evidence. It's about following wherever the evidence leads. Now, my side note, which is also a relevant note, which is also germane to this topic, is this. Judge Ann Downley in the Robert Sylvester Kelly case, federal case in New York, really messed up. And the digital forensics is going to come back for her too. She should have followed where the evidence led, and they did not have sufficient evidence. Jennifer Bongine has that in her appeal, when she filed her R. Kelly's motion for the appellate court. That's in there. Was not sufficient evidence because they said they had a bunch of video footage. They had a bunch of electronically stored information. They had a bunch of digital evidence, but they did not, from what I read, present it the way it should have been presented. And it goes back to authentication. It goes back to forensically sound evidence being submitted in the court of law. So the court noted that other evidence of contents of a writing or recording, such as Chandler's testimony, can substitute for the original or duplicate if the original is shown to be lost or destroyed or otherwise unattainable. But the government made no such showings. When asked on cross-examination to produce the GPS or its data, Chandler simply stated that he was not the GPS custodian. You're not the holder or the keeper of the data. You don't house the data. You don't collect, store, maintain, retrieve the data. And he was not, this person was not trained to do such. Again, this will kind of conclude this section. What I'm saying is electronically stored information is coming back for everybody. Okay, everyone. For Trump, Mar-a-Lago, when the FBI went in there and raided it. Well, sir, you're on footage taking documents that were classified from the White House. And they informed you prior to June 3rd, but definitely by June 3rd of this year, that they would be coming to collect those documents that he took from the White House illegally. So this Monday, when Mar-a-Lago got raided, why was he acting astonished? Your attorneys knew in advance. You knew in advance. They informed you. I'm sure they did. But maybe they didn't tell you. Or maybe, that's between him and his attorneys. But the point is this. The digital forensics, those digital fingerprints are coming back for Donald Trump. Those digital fingerprints are coming back for his administration that was underneath him. The digital fingerprints are coming back for Congress, who was involved in the attempted coup. The digital fingerprints are coming back for content creator on YouTube by the name of Tasha K. Why I'm talking about this Robert Sylvester Kelly trial that will happen towards the end of this month in Chicago with 2 co-defendants. She's also named in that. And then, according to documentation, they're saying she purchased his private information. We will follow wherever the evidence leads. No, they had a warrant. Let's be clear about that. The FBI had a warrant signed by a judge to go to Mar-a-Lago and retrieve evidence. That's what a warrant is for, search and siege. It was a search and siege warrant. And I'm sure it was an all-inclusive warrant. It's under seal right now. But the FBI had a warrant. When the FBI go in, they're supposed to obtain a warrant that's signed by a federal judge. And a federal judge did indeed sign this warrant. And the federal judge approved the search and seizure of properties within Mar-a-Lago. Search and siege. That's what they went there for. To collect evidence. And remember, they have probable cause. Rightly so, when you own video footage taking classified documents off the White House. Who does that other than a criminal who wants to go to prison? So, but again, Trump knew in advance, his attorneys knew in advance that they was coming to the premises. They knew that back in June. Okay. They came to get back what belonged to the White House. All right. In addition to other evidence. Now, back to this again. Content creator Tasha K. She is in this warrant because a officer from Wisconsin illegally accessed R. Kelly private information over 150 times, and allegedly it was stolen to Tasha K. It was sold to her. Now, she's all up in the mix. She's all in that documentation, as well as her live stream or pre-uploaded footage that she showed on YouTube. That's also in this case. Jennifer Bonjean makes sure that that was in a paperwork. So, again, just because prisoners are incarcerated does not mean that they don't have constitutional rights, and they still have some rights, and definitely privacy rights. So, again, the digital fingerprints is coming for everybody. So if you are out here a content creator, if you're not a content creator, you have to go to court. Let's make sure that you are aware, if you are the defendant and information is or evidence is being brought against you, and it's going to include some type of digital evidence, that it has been authenticated. Your attorney needs to know to challenge that prior to court and to challenge it again in court during the first trial. Don't wait. Challenge it, challenge it, challenge it. And if they are bringing anything in, it needs to be authenticated. That means it needs to be a forensically sound copy that's an exact duplicate. Nothing missing, nothing lacking, and nothing broken from it. It has to be a bit by bit copy of those hard drives, or exact copies of hard drives. Now, having said that, you all have a pleasant evening and a pleasant night. Thanks for streaming, everybody. Stay vigilant, stay actively engaged, stay cognizant, and watch out for that digital forensics and those digital fingerprints that are coming back for everybody. Bye-bye.